introduce the very first day of session in January and pre-file about 6 weeks in December. I want to give you some background and tell you why I think this is such a critically important piece of legislation, not just for the banking industry, but for the people of Missouri as a whole, because of some litigation and some positions that have been taken by the Missouri Bankers Association. Last year, the State Auditor's Office began an audit of the Department of Insurance of the state, the Financial Institutions and Professional Registration Division of Finance, and that's part of our statutory duties under Missouri Statute 29-200. So I basically inherited this office, or this audit, from my predecessor, Susan Monte. She started the audit, and I completed it. The Division of Finance's job is to monitor the health of Missouri's banks and savings and loans association, which is very important in these days of financial insecurity. The Division of Finance sets objective criteria by which it analyzes the banks to ensure that they're healthy, and they have published these criteria, how often they're supposed to examine the banks, what things they're supposed to look at to make sure the banks are healthy, and we go in and audit that. In this particular case, the audit that we conducted beginning last year, which I released several months ago, we found that savings and loan examinations were not generally conducted in a timely manner. In fact, half the time they were not conducted in a timely manner. That was a source of concern to us, especially, as I said, in precarious financial times. During that audit, we also looked at banks, not just savings and loans, and we found, based on the records we were allowed to review, which was only the records of banks that had gone out of business, 4 banks that had gone out of business the previous year, we found that the bank examinations were incomplete. They were based on outdated criteria. Following procedures was not documented. We found situations where required supervisory reviews had not occurred. And then for 75%, 3 of the 4 banks we were allowed to look at, they weren't even using the most recent version of the examination program. So for example, there's an examination program published by the Division of Finance dated December of 2007, but for 3 of the cases, the examiners were using an outdated examination book from March of 2001, which is different than the one that they're supposed to be using. We also found that they have agreements with other agencies like the FDIC and the Federal Reserve, which were out of date and needed updating to reflect new realities. And another finding we had was that the Division of Finance had actually overcharged the banks by $1.5 million just for a limited time period that we looked at. We don't know how far back this went, but during the limited scope of our audit, there was a major overcharge to the banks for the examinations, and the banks were due a refund. We questioned, well, if it's this bad for the 4 banks that went out of business, what about all the banks that are in business, which is a lot more. And so we asked for examination records from the Division of Finance for all those banks that are still existing and operating in Missouri. The Division of Finance refused to turn over the documents. We issued a preliminary report on May 3rd of 2011 that summarized the problematic findings we had. You know, I have a grading system I use, excellent, good, fair, poor. We graded them fair on what we could look at, which was like the equivalent of a C if you're in school. And then we said incomplete, really, for the rest of it, because we weren't able to look at the other examination records. So I issued subpoenas pursuant to my subpoena authority for the records the Division of Finance would not provide. And then they filed a declaratory judgment action. This is the Division of Finance, filed a legal action against my office, stating that it could not turn over the records that I wanted to look at, or they would be prosecuted for violating confidentiality of bank records. Now, my office is required to keep those records confidential anyway. We frequently look at confidential records of other agencies, boards, commissions, and we keep them confidential. We did not agree with the position that the Division of Finance had that they could be prosecuted or were prohibited from providing those documents, because we look at documents like that all the time. In addition, the Division of Finance tried to enlist the support of the FDIC and Federal Reserve to resist our examination, but they actually sided with us. We entered into a written agreement with the FDIC and a written agreement with the Federal Reserve that said as long as we protected the confidentiality of the information we looked at, you know, we don't want customer information to be made public. We understand the banks don't want that. They were totally with us. So we had an agreement with the FDIC and the Federal Reserve, and our only opponent then was the Division of Finance in this endeavor. But I really wanted to resolve this without any dispute, without even having to do something like I'm doing today. So in June, I called Governor Nixon, and I've interacted with him on numerous occasions since I've been auditor. He called me back and explained Governor Nixon, look, we understand the need for confidentiality, and we are willing to work with the Division of Finance to ensure the confidentiality of individual depositor information, bank records, things like that. But we need to look and see if the Division of Finance is doing its job with respect to existing banks, since we found some pretty significant problems with the banks that went out of business, and we were concerned about that. The governor was very receptive to what I had to say. It was exactly, I think, the way government should work, where partisan issues were cast aside, and we tried to work out a constructive and positive outcome to the situation. Eventually, my staff worked with the governor's chief of staff and some of his other people in the Division of Finance, and we were actually able to reach an agreement also with the Division of Finance. That agreement ensured that my office had access to all the records we need to ensure that examinations are being conducted in a timely manner and in accordance with established criteria. We agreed, as we always had, the division could redact bank names. All we were going to see was it's bank A, B, C, D. We wouldn't even know what bank we were looking at. And that's fine with us, because we're not really interested in the health of individual banks or in exposing information. We're just trying to see if the examination process follows established criteria like we do for every state agency. We don't question the Department of Mental Health's ability to cure people's mental health. We don't look at test scores when we go into school districts. We don't look at the substantive job of the underlying entity. We only look to see if the proper processes and procedures are being followed, basically through objective criteria. Almost immediately, we thought we had it resolved. We got the audit started. Now keep in mind, we had the Federal Deposit Insurance Corporation okay with it, the Federal Reserve, the Division of Finance. We were all fine. We started the audit, but almost immediately, the Missouri Bankers Association, under the leadership of Mr. Max Cook, sued the state auditor's office to try to stop the audit in question. I'm not here to talk about the lawsuit. That's not resolved yet. I will say, we plan to defend this lawsuit vigorously. If we lose at the trial court level, we'll take it all the way up to the Missouri Supreme Court. This is a very important issue of accountability, and we plan to pursue all legal remedies. And I believe the state auditor already has the authority to do these audits, as has been agreed to by the FDIC, the Federal Reserve, and the Division of Finance, and the Attorney General, for that matter. But I think it's such an important issue, and particularly with respect to the performance audit issue, which I'll discuss in just a minute, that I've decided to pursue a parallel track of both continuing on with the litigation to its absolute end. We will under no circumstances drop the litigation, but also pursue a legislative remedy that makes it very, very clear that we are to do this. So today I'm announcing, with the support of some very, very accountability-minded legislators like Representative Sue Allen here and State Senator Brad Lager, who was going to be here. He gave you all a quote, I think, but had to run back to Kansas City, that we are going to issue some legislation, a copy of which I've given to you all today, which will direct me to conduct the audit in question, first of all, tell me I have to do it. It will also clarify the legality of performance audits. This is a performance audit. We're looking at whether the Division of Finance followed established objective criteria in its audits. And also will put restrictions on the Division of Finance's employees' ability to work for banks for 2 years following employment with the Division of Finance. Stop the revolving door. One of the concerns we've had is maybe, we don't know, but because we haven't looked at all the records, but maybe one of the reasons why there's such resistance is there seems to be a very close relationship between the Bankers Association and the Division of Finance, which is maybe why the oversight has been so lax from the documents that we've seen so far. And by putting that revolving door to an end, we might have more aggressive oversight by the Division of Finance. So we think that's important. And that's very common. When I left the federal government, I had similar restrictions put on me on business that I could do in front of certain agencies that I'd worked for. That's very common, these 2-year restrictions, but they don't exist right now. This is a very important time for banking accountability, a very important time. Since the beginning of 2008, 12 banks in Missouri, including 3 nationally chartered banks, have failed. That's 50 branches that are now out of business and a huge bill to the taxpayers. In 11 counties, these banks have $2.3 billion worth of assets. So we're talking serious money and serious risk. With support of the members of the General Assembly, I'm very pleased to be able to announce the Bankers Accountability Act of 2012, I will let Representative Sue Allen talk in a little bit, and we have a quote from Brad Lager. But I want to talk about another part of the act. First of all, as I said, it directs me to do the audit in question. And that's the ultimate thing. We are going to do this audit one way or the other. As long as I'm here, we're going to be pushing to do this audit because I'm concerned about the safety of depositor depositors who deposit in Missouri banks. But there's also another issue, the ability of any performance audits to be conducted. Performance audits, as I said, are audits where we look and see if agencies, boards, and commissions are following the laws and objective published criteria in their efforts. We don't second guess their jobs. We don't look into, as I said, whether banks are healthy or mental health is being cured. We look at whether these organizations are following the procedures that apply to them, and that's all we do. This legislation basically says that we are allowed to do performance audits, even though we feel we already have that authority. This year alone, performance audits conducted by my office have uncovered over $500,000 in embezzlement in 4 different places, and millions in savings for waste and abuse of public funds. These performance audits have saved the state hundreds of millions of dollars over the decades by pointing out where people are not doing their job, or in some cases, like we found 4 times this year, actually stealing money from the state or counties or local entities. If not for performance audit capability, there would really be no guarantee of accountability in Missouri. People who want to commit fraud, waste, or abuse would pretty much have free reign across the state. Now, I want to point out, performance audits are conducted in all 50 states. You can go on the websites of every state comptroller or auditor, there's no exceptions, they all conduct performance audits. If you look back behind me, you'll see Kit Bond's picture up there, a very old picture of Kit Bond in 1971. He started performance audits in Missouri. Every auditor since then on the wall, all the way up through Susan Monty and me, having conducted performance audits. Claire McCaskill had a performance audit division in the state auditor's office. And in fact, Margaret Kelly, who held the office for 12 years, and Claire McCaskill have filed affidavits in support of my position in this litigation. So you have bipartisan support for performance audits. It's not a political issue, it's an issue of accountability. No governor or attorney general has ever challenged the state auditor's authority to conduct performance audits. And if the Missouri Bankers Association is successful in shutting down performance audits, we will be the least fiscally accountable state in the entire United States of America. That is not an overstatement, that is a fact. In the midst of a prolonged budget crisis, high unemployment, financial instability, a lot of it caused by banks, I am firmly believe that we have to fight through every possible forum for the ability to do this audit and for the ability to do performance audits. I think that I'm going to pursue the litigation, as I said, and I'll work hand in hand with the legislature to pass this legislation clarifying the state auditor's ability to conduct performance audits. Now, think about this. The Tea Party is out there supporting greater accountability. You've got the Occupy Wall Street movement, which is very distrustful of banks. So both sides of the political spectrum, I think, would be very supportive of this. Governor Nixon directed the Division of Finance to work this out with me, and we did. The Division of Finance signed a contract to do this audit. The FDIC signed a contract to allow the audit. The Federal Reserve signed a contract to allow the audit. The GAO, Government Accountability Office manual, provides for audits like this and gives the guidelines for it. Missouri state auditors, since Kit Bond, have been doing performance audits. Susan Monty started this audit. Claire McCaskill filed an affidavit in support of this audit. Margaret Kelly filed an affidavit in support of this audit. Performance audits are conducted in all 50 states, and every high court across the United States that has been presented with a challenge to performance audits, including courts in New York and elsewhere, have always sided with the state auditor's ability to perform performance audits. It should not even be an issue. So I have a simple question. Mr. Cook, Missouri Bankers Association, what is it that you are hiding from the people of Missouri? Why are you trying to shut down this audit and all performance audits in Missouri? Why are you showing disdain for accountability unlike anything I've seen in my 10 months as auditor? I will continue to fight for accountability in the people of Missouri in the courts and in the legislature until we have completed this audit. Thank you, and now I'd like Representative Sue Allen to make some words.
Thank you. I'm very happy to be here today in support of Auditor Schweich and the Bankers Accountability Act of 2012. I will introduce this legislation, and this will be a top priority for me. I was surprised to learn that during these precarious financial times, there could be any attempts to prevent a state auditor from making sure that use of proper criteria, standard rules would be delayed or avoided in order to allow for timely examination of banks and savings and loans in Missouri. I believe that, first of all, transparency and accountability is what government needs to be presenting. And we already have existing statutes to give the auditor's office the ability to conduct these audits, but what the bill we will be filing then is just going to further clarify and strengthen what we have. There should be no doubt. And again, what I believe we always need most is oversight, and that's what this should produce. As elected officials, we must protect our citizens and their resources. We must all be open and honest about how government operates. The Division of Finance has the duty to ensure that Missouri banks are examined properly to protect the hard-earned savings of our Missouri families. The state auditor has a duty to ensure that the Division of Finance is operating properly. The auditor is exercising that duty and responsibility in these actions. I am fully committed to this issue. I will continue to work for greater accountability for Missourians through this legislation. I very much value the support and efforts of our state auditor and his professional audit staff. Thank you.
That's all we have in the way of prepared remarks. I'm happy to answer any questions you might have.
Let me be clear.
Yes.
The division was ready for the audit. You're not able to do it because of the Bankers Association lawsuit, not because of anything that the division at the...
That's correct. The division originally sued to stop it, but I called the governor and we worked it out. And this is an example of, bipartisanship, which we don't have enough of around here, where the governor and I had a long talk about it. And then he directed his chief of staff to work something out, and we did. And we started the audit, and right after we started the audit, the Missouri Bankers Association filed the suit.
So your complaint right now is with the Bankers Association,
Exactly.
not the folks across the street?
No, exactly.
Have previous auditors done the kinds of audits that you were trying to do and completed them without a problem?
No. Last time was a try was like 11 years ago. And Margaret Kelly was told she couldn't have access to the records, so she did also an incomplete audit of the nature I just did.
So this is not then, this is a renewed issue rather than...
Right, but you might see Margaret Kelly's affidavit where she believes absolutely, think about the state of the banks today versus 11 years ago as well. We really need this audit now. Good question. Yeah, other questions?
Why did you pick 2 years as for the cooling off period?
Well, it's a pretty common in federal law for cooling off as a 2-year period. Sometimes it's 1, sometimes it's for life, but 2 years seems to be the norm. So we just went by what we've seen, similar cooling off periods in the federal context.
Are there other aspects of state government where there is that cooling off period?
I'm not a legislator, so I'm just concerned about what my office is doing. I'm not aware, but what I do know is that there are similar situations in federal law for those types of cooling off periods. So we thought it would be appropriate to prevent any sort of cozy relationship between the Bankers Association and the regulators.
I know you said you didn't want to talk about the details of the lawsuit, but in this case, are you being defended by Mr. Moore, who's on your staff, or by the Attorney General's office?
By Mr. Moore, but the Attorney General is defending the Division of Finance, so we're on the same side of the ledger in the lawsuit. Other questions? I really think, it's technical. Sometimes people think this is a technical accounting issue, but if this legislation and or lawsuit we're not successful in this, Missouri will literally be the least accountable state in the union. So it really is important, and I appreciate your taking the time to come here and write about it.
Why a law and not a constitutional amendment?
Well, it may have to be a constitutional amendment. We're still talking about that. It's tricky because if I'm denied the right to do it on constitutional grounds, I need a constitutional amendment. If it's on statutory grounds, a statute would resolve it. But even a constitutional denial might be based on the fact that the legislature did not grant the authority. So we have to see how the lawsuit goes, and we have to talk to members of the legislature to determine whether it's best to use a statutory remedy or a constitutional remedy, but it will be one or the other. It's a good question. We're still evaluating that exact issue.
But it sounds like if it needs to be a constitutional amendment, you might not know in time for next November's election.
Right.
You may have to look at 2014.
Right, but keep in mind, whatever happens at the lower court level only applies to the individual auditing questions. So we'll still go forward with all of our performance audits until the whole thing's through the Missouri Supreme Court. And so we plan to go forward unfazed, and no one else, I mean, if everybody else wants to sue to stop this too, we'll fight them as well. But right now, I think people recognize, I mean, when a petition comes in, for example, the only reason that people petition us, they don't want somebody to look at the financial statements. They're concerned about corruption in their government and misappropriation of monies and lack of competitive bidding. So we've never had anybody challenge our ability to do performance audits in those contexts, and we don't anticipate anything like that. Thank you all very much. I really appreciate your time.